me 1 second to make sure that I understand how this works. I'm going to jump right into this to make sure that there's plenty of time to talk about questions. As Casey said, my name is David Slottje. I'm the senior attorney at Community Environmental Defense Council based in Ithaca. And out to our visitors from Afton. In the front row, there are police here tonight, so we'll try to keep everything on the up and up. All right, so, tonight, just by way of overview, what I'm going to try to cover is, what I will cover is what is a public information session, what is a moratorium in general, what does the example moratorium that we're going to look at do specifically. I'm going to talk a bit about legal authority, the powers that local governments such as the Newfield Town Board have in a vacuum. We're going to talk about the gas mining statute. We're going to talk about some of the arguments and legal challenges that have been made or are typically made when a town starts to consider enacting protective measures such as moratorium. And we're going to talk about our view of the risks of waiting to act. As Casey said, in order to sort of keep this going smoothly, I would ask that people wait and we'll do all the questions at the end. All right, public information session, first of all, which is what we're doing tonight. Unlike a public hearing is a legal requirement. A public information session is not a legal requirement. This is just something that sometimes citizens, or in this case, the town board, have decided is a good idea. In this particular case, this is an opportunity for you and the audience, the public, to ask questions and make comments and suggestions about, in the case of tonight, a specimen or example version of a type of local law that the town board might consider. Is this too loud?
No.
Okay. So the type of specimen or example local law we're talking about tonight is a moratorium. What is a moratorium exactly? Moratoria, by the way, is the plural of moratorium. You will probably hear me tonight say moratoriums. That's incorrect, but that sounds better to my ear than moratoria. But I just feel the need to do this so that you don't walk out of here and you guys say moratoriums when that's wrong. A moratoria is a very common but very specific type of land use law. And it is, in form, it is identical to every other type of local law that you have ever seen in form. The only difference is that a moratorium has one sentence in it that has what I call a burn-off date, an expiration date. Some people call it a sunset clause. So it looks like any other law you've ever seen, except that it says, by its terms, it says that it expires on a date certain. All right? As far as what it does, there's two places that one typically uses a moratorium. I'm going to talk about the second situation where a town board considers a moratorium. And that is where the town board sees on the horizon a particular land use that either the town knows is going to come into the town or the town board thinks might come into the town. All right? The town board is not certain that it's coming in, and here's the real important point. The town board has not determined whether or not allowing that particular use into the town would be in the town's best interest. All right, so the town board sees a use on the horizon. In this case, it's unconventional gas drilling, and the town board has not decided, has not determined yet whether it would be a good idea or not to allow that use in. So that is where one of the two places one uses this special kind of law called a moratorium. And that's what we're talking about tonight. All right. It's maybe adopted as a stopgap measure designed to temporarily halt development while the town considers inter alia, that just means among other things, comprehensive land use changes. So again, you see a land use on the horizon, you don't know whether it's a good idea for your town or not. This is the perfect tool for the municipality to say, you know what, we're going to use this, and this will allow us to sort of do, if any of you are teachers or have kids, it allows you to do a timeout, okay? before the use comes to town. There's a lot of sort of urban legends out there about how long a moratorium can be, whether it can be extended. There is no requirement in New York State law that prescribes how long a moratorium can be by date. What the law says is that given whatever you're trying to do with that moratorium, the time of your moratorium has to be reasonable. That's all the law says. And it's also crystal clear, despite what you might hear some places up to the contrary, there is no limit on how many times you may extend it, and there's no limit to how many times you extend it. But each time you extend it, when you first pass, if you pass a moratorium, you need to make sure that the initial duration, let's say 1 year, because that's what's on the example I'm going to show you, that has to be reasonable given what you're trying to do with it. And if you extend it, let's say you do a 1 year moratorium and you extend it for 6 months, then when you do that extension, you have to be able to justify that an 18-month period was reasonable given what you were trying to do. 12 months from the initial moratorium and then 6 months for the extension. Okay? Before I get into the guts, the substance of a moratorium, there's 2 points I want to make that are really, really important. As a general matter, I don't read my slides, but I'm going to read these next two because they're really important. Point 1 is that any time when a town board considers whether a moratorium should be enacted, and then if they decide, they go beyond that, and they decide they do want to enact a moratorium, those decisions do not mean, as a matter of law, they do not mean that the board members have made up their minds about whether, in this case, gas drilling is an appropriate land use in the town, or whether fracking has been proven safe. So if it turns out that the town board decides that they are going to formally consider a moratorium, if it turns out that they decide they're going to enact a moratorium, that does not mean that anybody who votes for that moratorium has determined that gas drilling is not an appropriate use for this town. That's not what it means. The only thing it means is that those town board members believe that it's in the best interest of the town as a whole to study and gather more information during the moratorium period in order to help them make an informed decision. Point 2, before I get into the guts. A moratorium is not zoning. Sometimes people will say if you enact a moratorium, you're bringing the dreaded zoning word to our town. That's not right. It's not even close to being right. Anybody who says that, if they're acting in good faith, just doesn't understand. If they're not acting in good faith, they're trying to scare you. By definition, as a matter of law, anybody tells you this turns the town into zoning, you'll never hear that from a lawyer. So if they say that, ask if they're a lawyer, and then get your advice from a lawyer. So a moratorium is not zoning, and enacting a moratorium does not somehow magically turn a town into a place that has zoning. All right, so with that out of the way, the particular example moratorium that we're looking at tonight is structured as follows. Section 2 talks about the legal authority that the town board would be, in the case of this example, has relied on, the intention of the town board in enacting the moratorium, and then findings of fact. And I'll explain why those are important in a moment. Section 3 is the defined terms. Basically, anytime you look at a law, sometimes when you see a law and it says your dog has to be licensed, there's not going to be a definition of dog because everybody knows what a dog is. But sometimes, depending on what the law is, if it covers a relatively technical subject matter, you've got to look, and the law relies on defined terms. In this particular type of law, in this particular example, there are very specific defined terms, and we'll cover those as we talk about this. Section 4 is actually what is covered, the guts of the moratorium, and conversely, what is not covered by this particular specimen. Section 5 and 6 are the penalties. There's always a penalty for violating the law when you pass a law. So this articulates what those penalties are, and then a concept called grandfathering, which I'll explain when we get there. And then 8 and 9, the final sections, are something combined into something called a hardship exemption mechanism, which basically I'll get into when we get to that section. But it's a provision that is built in so that if anyone considers themselves to be aggrieved and that this particular law causes them what the law calls an unnecessary hardship, then there's a mechanism in the law that essentially gives the people the opportunity to appeal. All right, the findings of fact, this kind of law, any kind of law, but any kind of law, the legal standard that the town board has to satisfy in order to pass this kind of law or any kind of local law is the lowest legal standard that the law recognizes. It's something called arbitrary and capricious. There is no lower standard. And in order to satisfy the arbitrary and capricious standard, all you have to do when you're passing a law is show that there is some connection, some nexus between whatever the harm is that you perceive when you enact this law. And by the way, you don't have to be correct when you guess that there's a particular harm coming. And a judge can't even look at that as a matter of law because of something called separation of powers. Nobody can even criticize that. You can sue for anything. But a judge can never even look at the question about whether you were right if you thought, hey, there's a use on the horizon that could be a problem. If you see it, that's the end of the inquiry. All right? You then have to show whatever those perceived possible risks are, you have to make sure that there is a connection, a nexus between what you think those risks are and the law that you are passing. So, in the particular, so that's why we have findings of fact, so that we can defeat any argument that passage of a law like this is arbitrary or capricious. In the example before us, some of the findings of fact, I'm just going to run through to you. Town residents are dependent upon aquifers and wells. I assume that's the case here in Newfield. Maintaining the quality of water resources is critical to protecting the environment of the town, the general health and welfare of town residents, and the local economy. This is true about almost every town in upstate New York. So I'm assuming it's true here. Certain of the activities described in this case, Section 4 of the local law, we'll get to what those are. Those are the activities that are covered by the moratorium. Have the potential, there doesn't have to be certainty, but they have the potential to damage surface and groundwater resources in the event of, by way of example, human error, power outages, flooding. We've all seen all of those things. Engineered materials that experience stresses beyond those for which they were designed. Again, the judges don't get a bite at the apple to say whether these findings of fact were reasonable. But if they did, there's no way anybody could argue that these are not reasonable, no matter what side of the issue they're on. Allowing the activities prohibited by, in this case, Section 4, but have the potential. Doesn't say it's a certainty. It doesn't have to be a certainty. Have the potential to have negative impacts. The negative impacts in this particular law that were recited included traffic, noise, vibrations, damage to roadways, degradation of water and air quality, damage and loss to open space, and so forth. So, in this particular case, there were 3 or 4 pages of findings of fact. There frankly usually are in these kind of laws. I should tell you that there are about 100 towns, towns meaning municipalities, cities, villages, and towns, in New York State who have passed laws such as this, equivalent to this, or in the process of having passed these laws and will have passed by the end of May, 100 or so, okay? And in virtually 90 some of them, with which I'm familiar, they all have about 4 or 5 pages of findings of facts like this. All right. Now, what does the actual operative terms of the moratorium, what does it look like? It's real simple. From and after the date of this law, no application for a building permit or other town level approval shall be accepted, processed, approved conditionally, or issued for construction, establishment, or use of any land, body, water, building, or other structure for any of the following. And then we go into whatever activities it is that we would cover in the moratorium. In the example moratorium that we're looking at, there were there were three broad categories of activities covered. All three of these activities are defined terms. In other words, you don't just say, try to figure out, the first one's nat gas exploration activities. You don't simply say, well, I know what a natural gas exploration activity is. You go to the law, you look at that section, and that spells out, that's what a defined term means. It gives you a definition of what those are. So you've got nat gas exploration activities, you've got nat gas extraction activities. Those are, even though they're defined terms, they're essentially just what you would expect them to be. The third category you probably won't be able to figure out on your own, and that's something called nat gas support activities. But again, that is a very specifically defined term. It is not the roach coach or the lunch wagon that travels to the well pad site to sell sandwiches to drillers. That's not what we mean by support activities. Support activities is a very narrowly defined, drafted, defined term, which we'll get into. That concept of support activities is in turn tied in this particular law to a definition of nat gas extraction, exploration, or production wastes. And here's another spot where I'm going to read the slide to you. The way that this starts, this particular defined term, is any of the following in any form, whether or not such items have been accepted or exempted from the coverage of any federal or state environmental protection laws, or have been accepted from statutory or regulatory definitions of industrial waste, hazardous substances, toxic waste, and so forth. That's very unusual drafting, and let me tell you why it looks the way it does in this and most of these other laws that follow this approach. The primary and most important environmental protection statutes in this country at the federal level, and some of the more important ones at the state level, all follow the same three-part format, A, B, and C. Lawyers call them listing statutes, because the first part, which I'm going to call Part A, lists all of the compounds, chemicals, substances, and so forth that the particular law cares about. So it'll say xylene, benzene, toluene, and so forth, and it'll go all the way down, depending on which law we're talking about. At the bottom of that section A, it'll say each of the foregoing chemicals, compounds, etc., is herein referred to as, and two or more herein collectively referred to as. And then depending on the law that we're talking about, it will say hazardous substances, hazardous materials, toxic substances, and so forth. That's Section A. Section B, I'm going to skip for a minute. Section C then goes on and says, any person, and person is defined as you would expect it to be, which is not just natural persons, but it's any companies, corporations, LLCs, and so forth. Any person who handles, disposes, transports, utilizes, releases is a magic word, employs any verb you can think of. Any person who insert verb, a hazardous material, hazardous substance, toxic substance, depending on what law we're talking about, shall be and is hereby made subject to the following requirements. And then they go into, at a minimum, hundreds, and in some cases, literally thousands of pages, including the regulations that say anybody who touches any of this stuff, here's what you got to worry about. That's Section C. Section B, which I skipped, is typically one sentence, sometimes two sentences. And what it says is, notwithstanding any provision hereof to the contrary, in the event that the person handling, transporting, disposing, releasing, utilizing, employing, again, insert verb, is in or is employed by or associated with or under contract with people in the oil and gas industry, then and in such event, such chemical compound and so forth, shall not be considered to be a hazardous material, hazardous substance, toxic substance, and so forth. Get that? So I couldn't make that up. And that's not just the so-called Safe Drinking Water Act, that's not the so-called Cheney 2005. This is everything, folks. CERCLA, RCRA, any federal, almost any important federal statute you can think of, and some of the important state ones. So if you do decide if the town board does decide that it wants to enact a protective law such as a moratorium, and they say, you know what, we're tired of paying lawyers, to kill trees, just make it simple. And they say, we're just going to have a law that says, thou shalt not use hazardous materials in my town, you've got a big problem. Because when your code enforcement officer goes and gives a ticket to that person in the gas industry for handling what, if anybody else touched it, would be a hazardous material, hazardous substance, and so forth, they're going to say to you, or their lawyer's going to say, I'm employed by, associated with, under contract with, etc., somebody in the gas industry. So it's not even a hazardous material or hazardous substance or toxic substance, whatever it is, when I touch it. Okay? That's a really important point, and that's why this is drafted the way it's drafted. Okay. Now, those support activities, I told you, that's not the guy who brings the lunch sandwiches to the people on the rig. Some of these support activities are also defined terms. And I should say before I talk about what these are and what they mean, is that this is what this particular town did. These are the support activities that this particular town did. I think, are we using Carol? I don't know, they're wherever this one came from. But you don't have, your town is not limited to these. You can put other things in, and you also don't have to have these in. You could take any of these out if you wanted to. All right, but in this particular one, here's what support activities are. Compressor stations. Let me tell you about land application facilities. The biggest problem that the gas drilling industry has, from a cost standpoint, is handling their waste. There are two different types of waste streams. There are liquid waste streams and solid waste streams. And when I say solid waste, I don't mean like solid waste that the lawyer talks about, like sewage treatment stuff. I'm talking about not liquid. In the Marcellus formation, not in every formation, but in the Marcellus formation, by definition, the Marcellus formation is radioactive. By definition. Okay? So, before people frack, before they put any water in, before they do anything else, before they put chemicals in, the first thing they do when they start drilling, they bring up these things called drill cores. In the Marcellus formation, some portion of those drill cores are radioactive. So in Pennsylvania lets the drilling people pretty much do whatever they want. But they won't let them dispose of the drill cores from the Marcellus in Pennsylvania because it's too dangerous. So what's going on right now as we speak is that the drilling companies take those drill cores and associated solid waste, they put them in dump trucks, they drive across the border to New York State, they find some farmer or somebody with idle agricultural land, maybe he's farming it, maybe he's now idle with it, and they pay these people X dollars a dump truck load to accept it and spread it on their farmland. Now the farmers, like many of us, they need money. These are tough times right now. So the farmers say, "Man, I'm not sure. Is this safe?" And the gas guys go, "It's not hazardous." And I showed you why they can say it's not hazardous. So everything on this list, and again, you can take some of these things out if your town wanted to. You could put additional things on, but everything that's on this list happens as we speak. Every day it's happening right now. This is not some list where somebody sat around, a bunch of lawyers sat around and thought, hey, what sort of terrible things might happen? Everything that's on here does happen and is happening right now as we speak. Okay? So that's land application facility. It's a defined term. When you look at it, you see that it's basically taking that nasty stuff and spreading it over farmland. Underground injection, the other waste stream that these folks have to deal with is the liquid waste stream. The fracking process basically involves taking theretofore pure water, mixing it with sand and chemicals, and then injecting it under high pressure. It's basically sort of doing little mini explosions under the ground to open fractures that are already there, and then pulling the stuff back up. Okay, so that liquid that started out as water, when it comes back up, it's got two generally large classes of sort of bad stuff in it. It's got the bad stuff that the frackers put in to begin with. All right? And then it's also got, there's a bunch of bad stuff underground, a mile underground. It doesn't hurt us when it's underground. If any of you watch National Geographic TV or Discovery Channel or anything, you know, you probably know that if you go down a mile or 3 miles under the ocean, there, even where there's no light, there's all kinds of life forms. There are life forms under the earth a mile or 2 down. Some of them can be very, very harmful when you bring them up to the surface. Okay? That's why one of the things that the fracking people put into that fluid is something called biocide. Bio, you remember from high school biology, is life. Side, you remember from cop shows, is like homicide, fratricide, is killing. So a biocide kills life. They put the biocides down there because there's living stuff down there. All right? But anyway, when they bring that stuff up, it's got all that stuff, and it's also got, naturally occurring radioactive materials called norm. It's got heavy metals, barium, strontium, all kinds of things that can hurt you. All right? So what they used to do in Pennsylvania with this waste stream is they would dump it in the river. Now, Pittsburgh said to the people of Pennsylvania, don't put it in the river anymore. And Pennsylvania, again, which says to people, you can do whatever you want, even Pittsburgh said, don't put it, you can't put it in the river anymore. So then they said, okay, we can't put it in the river, we're going to start taking it to sewage treatment plants. And even Pennsylvania said, no, you can't take it to sewage treatment plants. So what they do now, when they do things legitimately, is they put it in big trucks, tanker trucks, and they drive to Ohio and they dump it underground. And that's called underground injection. Ohio, by the way, 5 weeks ago came out, and their analog to our DEC, I don't remember what it's called, Department of something, but whether it's DEP, DEC, whatever the Ohio analog is, they came out and they found formally, no question, nothing to talk about, they found that underground injection did, unequivocally, nothing to talk about, cause earthquakes. But Ohio said bring it anyway because we want the money. But be careful when you do it, all right? That's fine if they want to do that in Ohio, but if you use this form of law and you use that to define term of underground injection, that's what underground injection is. So if you put this in, you're saying you can't do that in our town. Underground nat gas storage is just what it sounds like. All right, some people say, look, if we pass a law like this, a moratorium like this, even though it's a stopgap, even though it's just a timeout, to give the town board an opportunity to sort of study this issue, you know, is that going to prevent me from using gas in my business? Is that going to stop me from cooking with propane? No. This particular law, and every single law that I have seen of these, and I've seen a lot of these, contains this provision. And it says, this law is not intended, it shall not be construed to prevent or prohibit supplying nat gas utility services to any buildings located in your town, or prevent or prohibit the incidental and normal sale, storage, use of lubricating oil, heating oil, gasoline, diesel, kerosene, propane, et cetera, et cetera, et cetera. So to the extent that anybody is concerned that if your town board does decide to pass a moratorium like this, you won't be able to barbecue, that's not accurate, and the law specifically deals with it. All right? Now, in this particular specimen, the initial term is 1 year. I told you the only difference in form, required form, between a moratorium and a regular land use law is it's got this expiry or burn off or sunset clause, whatever you want to call it. Here's what it looks like. This law will take effect on the beginning date and shall burn off or expire on the first to occur of A, that date, which is in this case 1 year, or 2 in the whole, the effective date of a duly enacted repeal. So that's important to remember. So what this is saying is even if it's a 1 year law, your town board always has, in fact, they have this ability, even if you didn't put that 2 in the hole in there, but they always have the ability to pull the plug. So if they pass a moratorium for, I don't know what they might do, but if they decide to go with 1 year, and 6 months from now, something comes down, this new technology called fairy dust, where you can sprinkle it on the ground with no environmental impacts, and all the energy just pops up, miraculously from the earth, no problem. Your town board just pulls the plug on the moratorium. All right, so it does not in any way tie the hands of your town board if you do something like this. And again, you could do that even if you didn't have that clause in there, but this one has it in there. Okay, grandfather. Anytime a town board, a municipal board passes a law that makes something that will now be non-conforming or illegal by virtue of that law, if the thing was legal to begin with, then the town has to do one of two things. You can either what's called grandfather it, which means, look, this thing used to be legal, it's not legal anymore, but it used to be legal, so we're going to grandfather you, which means you can continue that use. Or you don't have to grandfather people, you can write a check. Okay, so let's say that we were in Nevada, and it was possible on a town-by-town basis to have legalized gambling, and that there was legalized gambling in this town, and there was one gambling establishment, a casino, and then the town board decided that they were going to say, from now on, no more casinos. The town board could do that, but they would say, okay, if your casino was legal to begin with, you don't have to tear it down. Well, you could make them tear it down, but if you do, you have to write a check. So nobody ever writes a check. But they say as long as that casino was legal to begin with, you could continue it. That's called a non-conforming use, but it has to be legal in every way. It's got to have all its permits. It must have, even if it's a 20 years old casino, if they didn't pull a building permit when they were supposed to, if they didn't have a CO when they were supposed to, that's not a legal non-conforming use. But, so that's the concept. This particular law has built into it the notion that if there are pre-existing, legal, fully permitted gas wells in the town, not this town, the town that passed this, then after that, those laws will be allowed to continue as long as they have all their permits. Okay? Now some people look at that and say, what does that mean about fracking and things like that? Because we have heard that the fracking that is the subject of this 4-year draft supplemental generic environmental impact statement, the SGIS, has been around for 60 years. It's the same as your grandfather's gas pump. Not true, where you wouldn't be going through, you wouldn't need a new SGIS, and you wouldn't have a 4-year process. But anyway, if it is true, it's no problem, because if they've got all their permits and their grandfather, they're fine. Now, but as a matter of law, there is no such thing as a legal well in New York State, fracked or otherwise, as a matter of law, that uses more than 80 or 100,000 gallons of water. That's the law. The DEC would tell you the number 300,000 gallons. There's no legal basis for that, they say that. The law, but whether you're talking 80,000 or 100,000 or 300,000, that's one thing. So if you got a permit, you can frack to the tune of 80 or 100,000 or 300,000 under the grandfather contract. You can't do the fracking that people want to do now, with it between 3 million and 8 million gallons per fracked well. Okay? Now, I bring this up because in some places, it turns out there are people who have gas wells in their backyard or in the back 40 or whatever that are not permitted. They're not legal in that sense. They've had it for 20 years. Some of them even say, it's so good, I'm going to run a line to my brother-in-law. We found this as we've sort of done these kind of talks. They haven't blown up yet, but those would, if you got one of those wells, that would not be grandfathered if your town board passed a law like this. Because whether it's been there for 1 day or 20 years or whatever, that's not it doesn't have all its permits and it's not legal. Okay? Hardship exemption I mentioned before. There is a concept in the New York State law called unnecessary hardship. That's a defined term. It's actually in the law. And this particular law in front of us bootstraps on that unnecessary hardship concept. And what it says is that if you feel that you're aggrieved by this particular moratorium, even though it's, in this case, it was only 1 year, you have a mechanism. This law has built into it, and we recommend that everybody who does these laws build such a mechanism in. You have this mechanism to essentially appeal, and using the unnecessary hardship concepts that already exist in New York State law, you can attempt to get an exemption from this law. Okay. All right, so that's sort of what, that's the first part of it, what this particular law, example law, looks like. Next thing I want to talk about very briefly is town board, local government power in a vacuum. By the way, we all know that the United States Supreme Court is the highest court in the land, and that they are the last word and arbiter on anything that comes before them. In New York State, the Supreme Court is the trial court. It's the first level court. It's not the highest court. The highest court in New York State is the Court of Appeals. So anytime that a lawyer or anybody else, anytime anybody's talking to you about New York State law, our recommendation is that your ears prick up when you hear the word Court of Appeals, the phrase Court of Appeals, because that's where it stops with the Court of Appeals. Every single case that I give you tonight, whether or not I say so, is a Court of Appeals case. It's the highest court in the state. If I cite a case that is not the Court of Appeals, I'll tell you when I do that, okay? So, sometimes people wonder, does my town board have the authority to consider protective laws like this? Excuse me. Court of Appeals says, yeah, absolutely. We don't mean, it's not just the right. In fact, the Court of Appeals, the highest court in the state, calls it an obligation in matters of land use and planning to anticipate future problems and to enact measures to guard against them, even though the anticipated events, those things you were worried about, even if those things you were worried about never came to pass. It doesn't matter, as I said at the outset of this. Okay? But there's no question in a vacuum, and I'll tell you what I mean by that in a minute, that your town board, that's the local legislature, has the right, again, this court would say the obligation, the court did say the obligation, to anticipate those problems and to enact measures to guard against them. There is something called municipal home rule law. It is a statute, okay? You have municipal home rule today. Some of you, depending on how closely you follow this issue, say, oh, well, Seward's got this thing, amendment for home rule. You don't need Seward. Home rule exists anyway. It's codified. The law is called municipal home rule law. There's a law that's called New York town law, New York village law. There's another law that's called municipal home rule law. That's what this is. That's why I capitalize it. This is a particular statute. It already exists. You don't need Seward or anybody to give it to you. And every municipality has something called police power. Police power is not the guys in the outside there, protecting us, which I'm glad they're there. Police power is the legal authority that every municipality has to enact laws to protect the health, safety, and welfare of the people in the town and the property in the town. Everybody has it. Every municipality has it. Okay? Most of the laws anybody enacts, any municipality you enact pursuant to your police power authority. So, this police power authority is perfectly aligned as a tool to address the impacts or potential impacts that you might be worried about if you or your town is thinking about passing a moratorium. Because as it says, you've got, that statute gives you the authority to enact laws for the protection and enhancement of your physical and visual environment, and to protect the health, safety, and welfare of the people and the property in the town, as I just said. So that's in a vacuum. In a vacuum, no question, you've got the authority. Your town has the authority to pass this kind of law. All right, we're not working in a vacuum. There is something called the gas mining statute. It is a state statute, The site is ECL, Environmental Conservation Law 23-0303, paren 2. 23-0303, paren 2. The gas mining statute, some people will tell you, some people who would like fracking to come to New York State will tell you, not very many lawyers. My estimate is that there are fewer than 10 lawyers in the state who will tell you that that this gas mining statute takes away your local authority. I do this presentation that I'm doing, or a variation of it, at least 5 nights a week, and for someplace all across New York State, Monday through Friday for various town boards, and then usually our weekends are full now because town boards are now scheduling special meetings on weekends because they want to, in those towns, it doesn't mean you should, but in those towns that want to enact a protective law, they want to get it done before the DEC issues drilling permits, and I'm going to talk about that. I would say between 70 to 85% of the time that I do this presentation, somebody who's on the other side, I say that affectionately, because of who's here tonight. It's not always, I don't always say it affectionately. But somebody on the other side, as has happened tonight, is taping the whole thing. And usually that goes up within a day or so, depending on how busy they are. Sometimes it can take 5 days on one or more pro-drilling sites. And they do a good job. The reason I bring that up is because when I say things like there are no more than 10 neutral lawyers in the state who would tell you that you are preempted, there is a lot of opportunity because there are a whole bunch of people out there whose job is basically to put our stuff up on the web and tape this. And there would be every opportunity for somebody to say, because I say it every single night, for somebody to say, that's not true. Tammy Johnson is a neutral lawyer and she doesn't agree. That's not true. Stevie Smith is a neutral lawyer and he doesn't agree. It hasn't been said. Eventually somebody will say it and I'll stop saying it. But I'm telling you, although there are a lot of non-lawyers who will tell you that this gas mining statute takes away your local control, there are fewer than 10 lawyers and no neutral lawyers. I say it, I don't mean it as a challenge, but I still have, nobody has shown me a neutral lawyer who disagrees with what I'm saying. Okay, so let's look at what this gas mining statute is. What it says is this local law authority that I told you about, home rule and so forth, notwithstanding all that, you do not have the right, you do not have the legal authority to pass local laws relating to the regulation of the oil, gas, and solution mining industries. You know what oil and gas is, solution mining is salt mining. So in this context, the question becomes, what does relating to the regulation of the gas industry mean? Court of Appeals, remember, is the highest court in the state. Until 4 weeks ago, well, let me get this right. 4 weeks ago, there was not a single case in New York State at any level that construed the meaning, the preemption language relating to the regulation in the context of the gas mining statute. Now, there are some people who will tell you there was one case, but they're wrong, and I'm going to show you why they're wrong. But so until February 21st of this year, there wasn't a single case at any level in New York State that construed the gas mining statute's language relating to the regulation in the context of the gas industry. All right? There are multiple cases at the Court of Appeals level, the highest court in the state, that construe that language, virtually identical language, at the time virtually identical language, from the mineral mining statute. In our state, mineral mining, which is basically sand and gravel, in some cases topsoil, is dealt with under a separate statutory scheme than the statute that deals with gas mining. So in the context of the mineral mining statute, the Court of Appeals has said unequivocally, repeatedly and unanimously, Those three things are very important from a lawyer's standpoint. Unequivocally, repeatedly, and unanimously, that the legal effect of language virtually identical to the language in the gas mining statute is that while a town may not pass a law regulating the operations and processes of the industry, which is the subject of that language, the town absolutely may prohibit that industry outright using land use laws of general applicability. Now these cases I'm talking about are in the context of outright prohibitions, and that is not what we are talking about here tonight. All we're talking about here tonight is a moratorium, but the same legal concepts apply. If you're allowed to do a moratorium, you're allowed to do the prohibition, and if you're not allowed to do the prohibition, you may not be able to do a moratorium. Towns actually have more legal leeway in the context of a moratorium. So again, what the Court of Appeals has said, not in the gas mining statute, they haven't looked at that yet, but in a very related context, that the legal effect of that language is that you may prohibit that outright, but you may not pass laws regulating operations and processes. Operations and processes are things like how far down they can drill, into what formations they can drill. You can't say, for example, Marcellus is radioactive, so we don't want you to do that. But you can go to Utica. You can't do that. Hours of operation, probably you cannot. There's a split of opinion. Bonding requirements basically require insurance and the like. Putting security up, you may not do that. Those are operations and processes. All right, so Court of Appeals has not looked at this in the gas mining statute context, but they have in the mineral mining statute, and they've said what this says. So, mainstream legal opinion is that there's no reason why that language in the gas mining statute should be interpreted any differently than the language in the mineral mining statute when, and I'll explain why I have a question mark in there now, that reaches the Court of Appeals. By mainstream legal opinion, I'm talking about, I'm not a neutral lawyer, I don't pretend to be a neutral lawyer, but I'm talking about neutral lawyers. I'm talking about people at law schools. Basically, neutral lawyers are people on the other side, it's not me, on this side, and on the other side, it's not people who represent landowners coalitions. Those people, by the way, it's those lawyers who represent landowners coalitions. Okay, anyway, so, neutral lawyers. But what I was going to say, they will make literally millions of dollars. Okay. And they get nothing if you do something like this. So the neutrals at the law school, the big firms, move along. Whiteman Osterman, they're a firm in Albany. This is significant because this is the firm that came all across upstate New York 2 years ago, and along with a firm called Delta Engineering. And they came in, they made appointments with every town board they could get, every city council, every village council, every county board of supervisors. And they said, gas drilling's coming, and you're preempted. They've changed their position very publicly now. They'll tell you you're not preempted. Association of Towns tells you you're not preempted. The Association of Towns lawyer. So, okay. All right. Arguments and threats against enacting these laws. Some of the common ones are, you shouldn't do this because it's wrong to tell people what to do with their property, or it's un-American. I understand the sentiment, but that's not the law. It's never been the law in this country. It's always been the law that if you own private property, there were restrictions on your use so that you did not do any harm to people downstream or downwind. Since before we were a country, that's the law. Property rights are always subject to limitations to prevent injury to rights of the community and neighbors. Court of Appeals. Sometimes people will say, don't do this because you're going to deprive me of the highest and best use of my property. Maybe, maybe not. The court says that doesn't matter. That's frequently the effect of a police power-based regulation. Look at this language in blue. The general welfare of the public is superior in importance to the financial profits of the individual. Court of Appeals, unanimous decision, 100 years old. Prevention of damage to others and community always legally trumps the right to exploit natural resources. this is one of those slides I'm going to read out loud. A town is not obliged to permit the exploitation of any non-natural resources within the town as a permitted land use, if limiting that use is a reasonable exercise of its police powers, to prevent damage to the rights of others and to promote the interests of the community as a whole. This is a unanimous Court of Appeals decision, and this language is why every neutral lawyer agrees that if, there are a couple lawsuits out there which I'm going to talk about, if those end up going to the Court of Appeals, this language is why the towns win at the Court of Appeals level. And in fact, this language is why they won at the trial court level, as I'll explain in a couple of minutes. The other thing people will sometimes say is don't pass a protective law, you can moratorium, because if you do, it's a taking. It's not. And I'll explain that. This takings is a very complicated area, and this slide oversimplifies it, but as this slide says, the notion that a property owner may establish a taking simply by showing that they could deny the ability to exploit a property interest that they therefore believe is available for development is untenable. All right. As I mentioned before, there are probably, I don't know the exact number, but there are probably 100 to 125 municipalities who either have passed laws along the lines of this particular specimen or in the process and will have passed it by the end of May. Two of the earliest towns that did that are Dryden here in our county and Middlefield, which is in Otsego County. Middlefield, if you don't know, is Cooperstown, where Cooperstown's a village within Middlefield. Long story short, Dryden passed theirs happened to be a zoning amendment, but again, the same law applies to what I'm talking about in the context of the zoning amendment, where their kind of laws and a moratorium, whether or not a town had it. They're all land use laws, and that's what we're talking about. So Dryden decided they were going to pass a land use law. Dryden decided they were going to pass a land use law, and it was frankly a little bit contentious in the town. Some people, actually most of the people from out of the town, but came in and basically said, don't pass that law, you don't have the authority to do it, you're preempted under this gas mining statute, and if you do, we're going to sue you for millions of dollars of takings liability. The court did it, I mean the